The repetitive and meritless legal challenges to the November 3rd election results from the Orange asswipe and his allies have sent one fundamental message: millions of votes cast by their fellow Americans are completely worthless. The Orange asswipes lawyers have argued for the wide-scale disenfranchisement of voters, including in Pennsylvania, and so far they have failed to convince the nation's courts of this. The Supreme Court rejected one of the cases from Pennsylvania Tuesday with the single sentence that the High Court action came with no explanation, yet it reinforced a pattern of lower court judges spurning a series of baseless appeals. The frivolous lawsuits that reflect the Orange asswipe enduring disregard for democratic values, and they further threaten to infect the American psyche by ceaselessly casting doubt in a fair election that Joe Biden had won. While the Supreme Court was silent in that regard on Tuesday, other federal and state judges have penned warnings about the Pumpkin Tits campaign up front to public trust in elections. The opportunity for further appeals is dwindling, as Tuesday marked what they referred to as the safe harbor deadline for the states to certify their election tallies. The free and fair elections are the lifeblood of our democracy, and charges of unfairness are serious. But calling an election unfair does not make it so. But charges require specific allegations and then proof, and we don't have either here," said the U.S. Appellate Judge Stephanos Bibas, who wrote last month rejecting a Pumpkin Tits challenge to the votes in Pennsylvania. Democracy depends on counting all lawful votes promptly and finally, and not setting them aside without proof, added Bibas, a 2017 Pumpkin Tits appointee to the Third U.S. Circuit Court of Appeals. The public must have confidence that our government honors and respects the votes. The Orange Fuck Weasels campaign and its surrogates have targeted states in which the election was close, but as Bibas observed, the final tally was not that close in Pennsylvania, and Biden won by roughly 81,000 votes among nearly 7 million that were cast. Other state and federal judges hearing Pumpkin Tits' challenge, for example in Wisconsin and Michigan, have similarly laced their opinions with concerns about the unprecedented and breathtaking requests that request to set aside the votes of millions of citizens who cast ballots, believing that they would count. When a federal judge in Georgia on Monday dismissed a complaint that was brought by lawyer Sidney Powell, a Pumpkin Tits nutlicker, the judge said that the challengers wanted perhaps the most extraordinary relief that was ever sought in any federal court in connection with an election. They want this court to substitute its judgment for that of 2.5 million Georgia voters who voted for Joe Biden, and this I am not willing to do. Last Saturday, a panel of the 11th U.S. Circuit Court Judge of Appeals swatted back the Orange Fuck Weasels appeal in another lawsuit that related to his loss in Georgia. The panel declared it lacked jurisdiction to hear a state grievance that was moot anyway. This appeal turns on one of the most fundamental principles of the federal courts: our limited jurisdiction, and federal courts are not constituted as the freewheeling enforcers of the Constitution and laws. Judge William Pryor wrote for the three-judge U.S. panel, adding, "When someone sues in federal court, he bears the burden of proving that his suit falls within our jurisdiction, and Lin Wood failed to satisfy this burden. Even if the dispute fell within their federal realm," Pryor added, "because Georgia has already certified its results, Wood's request to delay certification and commence a new recount are moot." Pryor, as well as Judge Barbara Lagoa, also on the 11th Circuit panel, had been touted by Pumpkin Tits in the past as a possible Supreme Court candidate. Pumpkin Tits believes that he might prevail if an election dispute were resolved by the U.S. Supreme Court. No, he still would lose either way. In September, he had urged quick action on his nominee, the dumb cunt Amy Coney Barrett, so the justice could not deadlock 4-4. The Republican-controlled Senate swiftly approved the dumb cunt Barrett over protests from Senate Democrats to succeed the late Justice Ruth Bader Ginsburg. On Tuesday, before the ruling, the Orange Fuck Weasel again insisted wrongly that he had won the election and referred to a possible role for the Supreme Court in his effort to reverse the outcome that favored Biden. Let's see whether or not that somebody has the courage. Yeah, they have the courage, but they're not going to overturn it for your fat ass. Whether it's legislators or legislatures, or just for the Supreme Court or a number of justices and of the Supreme Court, Pumpkin Tits said. until Tuesday's action in the Pennsylvania case that was brought forward by U.S. Representative Mike Kelly and other Republicans. The dumb cunt Barrett had not voted in an election dispute. The Kelly appeal sought to invalidate absentee votes that were cast under procedures that were set by 2019 state law. The Pennsylvania Supreme Court dismissed the lawsuit, and judges said that the complaint against the year-old law had been filed too late. In urging the High Court justices to let that Pennsylvania decision stand, Pennsylvania officials said the GOP challengers were asking this court to undertake one of the most dramatic, disruptive invocations of judicial power in the history of the Republic. The loss of public trust and other constitutional order resulting from the exercise of this kind of judicial power would be incalculable. The justices said nothing as they dismissed the case, and their individual votes were not disclosed. Sometimes in such orders, justices dissent without making their views public, so it's difficult to know at this point whether the dumb cunt Barrett or any other justice did not join the majority. The High Court had ensured that all filings in the Kelly case were in by Tuesday, the safe harbor deadline. Federal law sets other deadlines leading up to Congress's final count on January 6, including the next Monday, December 14th, when the state electors will convene. But results certified by Tuesday safe harbor are protected from the challenge. Before the November 3rd election, the Supreme Court majority had intervened in some state ballot disputes. On October 26th, the night that the dumb cunt Amy Coney Barrett was confirmed, an eight-justice court had issued an opinion that limited the counting of mail-in ballots in Wisconsin, and the rapist Brett Kavanaugh, Pumpkin Tits' 2018 appointee, signaled at the time an openness to some Pumpkin Tits campaign arguments. By a 5-3 vote, the conservative High Court majority had spurned arguments from the Democratic National Committee to allow an extension for counting Wisconsin absentee ballots beyond Election Day, as a lower U.S. court judge had decreed. Chief Justice John Roberts wrote that the U.S. District Court judge had wrongly intruded in a state legislative matter. The rapist Kavanaugh had wrote a concurring opinion that drew particular attention for citing part of the Nelson Bush v. Gore case regarding federal court scrutiny of state election decisions, and for referring to the chaos and suspicions of impropriety that can ensue if thousands of absentee ballots flow in after Election Day and potentially flip results of the election. Justice Elena Kagan dissenting and criticized the notion that legitimately that cast ballots would flip the results. She said, "There are no results to flip until all valid votes are counted, and nothing could be more suspicious or improper than refusing to tally votes once the clock strikes 12 on election night. To suggest otherwise, especially in this fractious time, is to disturb the electoral process." So if you like the video, give the video a like and subscribe to my channel, Marvin Mike, and also hit the notification bell so that you'll be notified when a new video comes out. Thanks for listening.